open court.
Oyez, oyez. Silence is commanded for the justices of the Supreme Court of Kentucky while they are sitting. All those having pleas to make or causes to prosecute, draw nigh and you shall be heard. This court is now in session. God save the Commonwealth. God save this honorable court. You may be seated.
President Ransdell. Good morning, ladies and gentlemen, and welcome to this special session of the Supreme Court of Kentucky. At this time, before the first case is called for argument, I would like to recognize Dr. Gary Ransdell, President of Western Kentucky University, and request that Dr. Ransdell come and give us a greeting, please.
Thank you, Chief Justice Lambert. It is an honor to have the court in Bowling Green, Kentucky, and on the campus of Western Kentucky University. This campus is known for its School of Journalism and Broadcasting, and among the nation's most precious freedoms, and certainly among the freedoms cherished in the Commonwealth of Kentucky, is that of freedom of speech and freedom of the press. And that is what we teach our students on this campus who are in our communications discipline. And this court is about preserving and nurturing our nation's freedoms, and we are honored that we have a program that is so represented by those freedoms. Have a wonderful day today. We're honored to have you here in front of a group of students who are very interested in what you do and how you go about it, and these students are from our community schools and students from this campus as well. So it's an honor to have you here. You're welcome on this campus at all times. And we're very proud of this court and everything you represent. And welcome to Bowling Green. Thank you.
Thank you, Dr. Ransdell. We're delighted to be here. Thank you. First, let me say a very warm welcome to all the students and teachers and interested persons who are in this courtroom today. I also want to express a special thanks to Dr. Ransdell and to the faculty and staff of Western Kentucky University for the warm and very kind hospitality that we've been shown since we've been here. I would also like to recognize a very special person who is here as an observer today. Mrs. Charles Reynolds is a guest in the courtroom today. Mrs. Reynolds' late husband was a distinguished justice of this court, Justice Charles Reynolds, who was a dear friend of mine and of all of ours. And Ms. Reynolds, we're delighted that you're here today. Thank you for coming. Okay, the case to be heard at this hour is Wood versus With Ahurst Laboratories. Mr. Shelton, on behalf of the appellants, I believe you've requested 12 minutes with 3 for rebuttal. Is that correct? And Mr. Clay, on behalf of the appellees, you'll have the normal 15 minutes. Gentlemen, as you can see, we don't have a system of lights here as we have in Frankfurt, so I will give you what we'll call a 1-minute warning. I'll let you know when you have 1 minute remaining on your argument. Okay, with that having been said, Mr. Shelton, you may proceed.
Mr. Clay, honorable justices, may it please the court. Plaintiff submits that the trial court and the Court of Appeals erred in ruling that this court's decision in Capital Holding Corp. v. Bailey bars plaintiff's claims for medical monitoring damages. Alternatively, plaintiff submits that to the extent Capital Holding does bar a claim for medical monitoring damages, that this court should overrule that case to such an extent. Capital Holding does not bar a claim for medical monitoring damages. In that case, Bailey was exposed to asbestosis or asbestos in the workplace. He made a claim for an enhanced risk of contracting cancer. He had, at the time, no present physical injury or harm. This court held that no cause of action in tort has accrued until the complained of conduct causes harm. Specifically, this court held that until such time as the plaintiff can prove some harmful result from the exposure, albeit he need not prove he is already suffering from cancer, his cause of action has yet to accrue. Ms. Woods, the plaintiff appellant in this case, has alleged that she is suffering a present harmful result from the ingestion of the diet drugs in question. Namely,
The harmful result.
I'm getting to that right now.
Fear?
The harmful result, Your Honor, is that she has been urged by a number of national well-respected medical organizations to undergo medical testing, which costs, at a minimum, $1,000.
And as I remember reading, she has not had any valvular regurgitation.
No, she is not. And in fact, we pled specifically in our Second Amendment complaint that she is not suffering from any present physical harm. That is because she's never been tested to determine whether she is suffering from physical harm.
She doesn't have the $900.
Actually, my client is a pensioner, Your Honor, who's about 73 years old, that does not have a great deal of money. The harmful result is the medical testing. It is a financial harmful result.
You mean the absence of medical testing?
I don't understand, Your Honor.
Well, you said the harmful result is the medical testing. That can't be.
No, the harmful result is the financial loss she will suffer, i.e. paying for medical tests, which is, and we have as alleged, has been recommended by at least 6 national health organizations.
And that you go on.
Now, I want the court to focus upon its language in Capital Holding, where it said that if you suffer a harmful result, you have a cause of action in tort. And then I would like the court also to consider the restatement second of tort, section 7, subpart 2, that states that a tortfeasor is liable for all harm, as opposed to just physical harm, past, present, and future, legally caused by the tortfeasor. Bailey, in Capital Holding, never made a claim for medical testing. His was an enhanced risk of injury claim. He never pled a present harm of any sort, physical or financial. Had he done so, I submit that this court would have ruled differently in that case. Had he gone and been tested for cancer and made a claim for those medical bills, if he could prove that the tortfeasor proximately caused the need for those medical testing and those bills, that he would have a claim for those medical bills.
Are you basically saying, counsel, that a claim for an enhanced risk and a claim for medical monitoring are conceptually different, that they're just different things?
Absolutely. One is a future harm, a speculative harm in the future, whereas Miss Wood right now has been told she should go spend $1,000 for medical testing or her life could be in danger. That is a present financial loss. And plaintiff submits to you, ladies and gentlemen of the court, that under the restatement, that is a compensable harm, that financial loss.
But what you're wanting, as I understanding it, is for this court to, or some court, to order these pharmaceutical laboratories to produce a certain amount of money that you could draw on periodically for additional testing. Or do you propose to be tested once a year or once every 5 years, or is there a limitation on at what point do you decide that the ingestion of these drugs did not cause any harm whatsoever and that no further testing would be required?
Your Honor, the courts across the nation that have adopted medical monitoring damages have set guidelines. They've recognized a cause of action, but they've set 6 guidelines. One of those goes exactly to your question, and that is you have to present proof to the trial court that, one, the medical testing will detect the supposed harm, and then through expert testimony, you have to establish to the trial court how often the testing should be done and at what intervals. So that is a fact issue that we were never even allowed to address in the trial court.
Wouldn't that depend on each individual person who is alleged to have been harmed? And doesn't that go to the question of whether this should be a class action or an individual lawsuit?
Your Honor, I would say no. I would point out that there was a national medical monitoring settlement that just held anyone who took this drugs is entitled to testing if you took it for a certain amount of time.
What are you asking for in this case that's different from that national settlement?
Your Honor, the national settlement, I believe, required that you ingest the drugs for at least 60 days. And I'm asking for a class to be established, I believe, of 30 days. We're also asking for punitive damages, which were not given in the national settlement.
How many proposed members are there to this class?
I simply have no idea. The national settlement required, it was a mandatory opt-out class, which means that unless you affirmatively opted out, you were included in the medical monitoring national class.
Do you have any person that you can identify who took this drug for 30 days but not 60 days that has had any harmful effects?
I do not, Your Honor. I've not been allowed to develop that proof yet. And I would also...
Well, I'm sure you're prepared to present it if we allow you to develop it. Do you have any such persons available?
As far as identifiable potential class members, no, Your Honor, I do not. I would also point out, though, that my case was not dismissed because I did not meet the requirements of a class action. I never got a chance even to argue my motion for class certification. I was thrown out on a motion to dismiss based upon capital holding.
For failure to state a claim.
For failure to state a cause of action, the trial court specifically relied upon capital holding. The Court of Appeals affirmed specifically upon capital holding. And I would add, Your Honor, that the Court of Appeals, it seems almost reluctantly did so by saying that even if we were to reconsider capital holding to allow a medical monitoring claim, we do not feel that's in our power to do so. That is up to the Supreme Court.
If you were to get back before the trial court, I assume there would also be an issue of whether this medical monitoring is needed. I know you've said that this national settlement says everyone should be tested. Mr. Clay has cited some authorities in his brief on page 2 that says that except for the early recommendations, the guidelines of medical groups have universally rejected the suggestion that asymptomatic former users even need this type of medical surveillance. Is that going to be, assume that would be an issue of fact as well?
It would, Your Honor. The national settlement included a parade of experts on both sides, Your Honor. Well, some saying it wasn't necessary, many others saying it was necessary. I can only point out that after millions and millions and millions of litigation dollars were spent, the federal district court judge presiding over the multi-district litigation in these cases found that the scientific evidence existed that necessitated a medical monitoring class action. Alternatively, if this court determines that capital holding somehow does bar a claim for medical monitoring damages, plaintiffs ask that this court overrule capital holding to that extent. Why? It should do so because a person whose tortuous conduct results in the need for a plaintiff to undergo medical testing should be held liable to pay for that testing. If I can give you an example, if one is involved in a car accident, rear-ended, and he goes to the hospital for x-rays and a medical examination, and that examination is negative, that person nevertheless has got to pay some medical bills. Now, who of the two individuals, the innocent person struck from behind or the driver that struck them from behind, should pay for those medical bills? Basic notions of fairness and equity dictate that the person that struck the individual should pay for those bills. That situation doesn't arise currently because of the no-fault system we have in the state.
Counsel, at the very least, even if one is able to make a distinction between enhanced risk in capital holding and the medical monitoring claim you're making here, at the very least you're asking us to create a new tort cause of action, aren't you?
Your Honor, you must be careful when you say new cause of action because I've asserted 4 distinct causes of action, and I'm asking for one remedy on each of them, damages, a medical monitoring damages, to put it more correctly.
Excuse me, are you asking for punitive damages as well?
I am, Your Honor.
And so you think that you would be entitled to punitive damages if you got tested and the test was negative? You still want punitive damages? Or do you concede that you would only be entitled to punitive damages if the test revealed that your client had actually been damaged?
No, whether she has been injured or not, Your Honor, under plaintiff's theory of this case, she would still be entitled to warrant of punitive damages, at least based upon the gross negligence of American Home Products. That is because, Your Honor, the evidence would show in this case, and we have alleged, that American Home Products knew for years that these drugs were harmful and could cause valvular heart disease, and nevertheless let people like my client take those drugs for a number of years. That, Your Honor.
Let me say this. If your client has not been damaged, and I guess it's been several years now and she's not no symptoms, then what we're talking about is paying up to $1,000 for her to be x-rayed and other tests that she runs, and you think she's entitled to punitive damages for going to the doctor and being x-rayed?
Yes, I do, Your Honor, and it's just not my client. I've asked for a class to be established here. They caused the need for hundreds of thousands of Kentuckians, Your Honor, to go get tested.
Well,
just
you
not
haven't
my
been able
client.
to identify one for me yet.
Your Honor, I've not been allowed to develop that proof yet.
I know, but I would think that if you have brought a class action lawsuit, which you have, that you could identify more than one person as being a member of that class.
Your Honor, my class would be all individuals in Kentucky that ingested the drug. And there's hundreds of thousands of those. That has been established.
Would any part of that class be precluded by the existence of the national settlement?
That is an issue, Your Honor, that I'm sure American Home Products will argue. I would argue that they would not, because the type of relief that we are seeking is different. The type of medical monitoring relief is different than what was given to them in the national settlement. If we lose that argument, though, Your Honor, and the trial court ultimately holds that to the extent you did not affirmatively opt out, you're out of this class. There has still been hundreds and hundreds of Kentuckians that have affirmatively opted out.
And your client opted out.
My client opted out. And I would note that most of those people opted out not because they were unhappy with the medical monitoring settlement, but because they had valvular heart disease and they were not happy with the amount of money they were going to receive for their personal injury under the national settlement.
Counsel, you have 1 minute to wrap up.
The clear trend in this nation is to allow medical monitoring damages. 6 out of 8 Supreme Courts in this country that have addressed this issue have allowed them. 2 appellate courts, two intermediate courts have allowed the damages and were not reversed by their higher courts.
The United States Supreme Court did not.
The United States Supreme Court, Your Honor, in the case you're referring to, simply held that it was not prepared to allow lump sum medical monitoring damages. In this case, we're asking for a court-supervised medical monitoring class. And I would also point out that the Supreme Court said, without limiting guidelines, we're not prepared to allow lump sum medical monitoring damages. Here, I've asked the court and presented the court with the guidelines that have been approved across the country by Supreme Courts. Frankly, I think Supreme Court dodged the issue in that particular case, Your Honor.
You say 6 of 8 that have considered this?
That's correct, Your Honor. And 7 states have certified medical monitoring class actions in fen-phen cases.
Before you leave, counsel, would you address the argument that's been made comparing by analogy the asbestos litigation in which 34 companies have gone bankrupt and they did not leave enough money for the truly injured people? If all the money is front-ended on medical monitoring, the people that are actually sick, the pharmaceutical companies go bankrupt, there won't be any money to pay the injured people.
Well, Your Honor, my response to that is, in this particular case, American Home Products is far from bankrupt. They made billions off of this drug. They're paying out billions to settle this, and they're still standing tall.
That's true of Owings Corning's, Johns Manville, Illinois Corning also.
All the more reason, Your Honor, to allow medical monitoring damages to deter these large corporations from putting products into the marketplace of the United States, which harms people. If the threat of potential bankruptcy is there,
that if they detect this earlier, it would reduce the damages on the back end?
that is an argument in favor of medical monitoring damages.
That's what I'm asking you.
It certainly is. If you can detect the disease in its earlier form, you, number one, limit the amount of personal injury, and number two, you limit the amount of litigation that would necessarily flow from the personal injury itself.
Counsel, your time has expired. You'll have time for rebuttal.
Thank you, Your Honor.
Mr. Clay.
Mr. Shelton, may it please the court. Irma Ray Wood has indeed had the relief she's requested. At volume 4, pages 419, 420 in the record on appeal is the echocardiogram and the echo monitor Doppler that she had on August 25th, 1997 after she took fen-phen.
That wasn't why it was dismissed, though, was it?
No, that was not why it was dismissed, but nevertheless, she has indeed had it, and it has established that she was asymptomatic. What she is an asymptomatic, completely uninjured individual. She invites this court, in essence, to return to law school and conduct a moot court oral argument based on hypothetical future injuries.
When you say, Mr. Clay, for the benefit of the audience, it's a little broader than we usually have. What is asymptomatic?
Asymptomatic means that there is nothing physically, observably wrong with her. She asks you to declare that a medical monitoring cause of action for a class of uninjured individuals should be a cause of action here in Kentucky. She asks you to ignore the fact that neither she nor any member of the class that she seeks certification for has been diagnosed with valvular heart regurgitation. And finally, she asks you to overturn the Capital Holding versus Bailey decision, a case authored 8 years ago by Justice Liebson with a court on which three of you, Chief Justice Lambert, Justice Wintersheimer, and Justice Stumbo, sat. It was unanimous on the issue of negligence, and that dealt with the issue of enhanced risk of future injury. This is what Judge Jennifer Kaufman spoke to twice in addressing how she would predict this court would come out on the issue of medical monitoring. First, in the case of Cooper versus Luttrell, she held initially that there would not be medical monitoring for the injured individuals. Later, the case, after she dismissed it from that viewpoint, was settled. A release was signed. The plaintiff then discovered that she had cancer, claimed that it was related to the PCB contamination that she had. She filed a new lawsuit, and Judge Kaufman held that the release barred everything. Judge Kaufman, in the Luttrell case, predicted that this court, in Capital Holding versus Bailey, would not allow a claim for medical monitoring. She further elaborated on this in an unpublished decision, which is attached as Exhibit C to our response to the motion for discretionary review. That is the Ambergy versus McGraw-Edison case. And in that case, Judge Kaufman clearly stated, and I'll quote her, if I can find it, in essence, that there was no difference between enhanced risk of future injury and medical monitoring, that it would not be a cause of action absent a finding of present manifest injury. And that indeed was the holding of Bailey. And I want to talk about Bailey after a close reading of its facts. In Bailey, Mr. Bailey was indeed exposed by friable asbestos. For the benefit of the audience, that means it was hot asbestos and it was falling all over him at his job at what was then known as Commonwealth Life Insurance at the tower down on 4th and Broadway. As
Your former
he...
office, right?
Sir?
Your former office.
No, I've always been for 25 years where I am. In any event, he later learned that he had been exposed. Commonwealth knew, they didn't tell him, but he found out subsequently. What Mr. Shelton and his client ignore about Bailey is the fact that Mr. Bailey had diagnostic tests immediately upon learning that he had been exposed. That is in the opinion. Despite that, he was not allowed to have reimbursement because he did not have, under the unanimous holding of this court, a present manifestation of physical injury.
Counsel, refresh my memory. Does the opinion reflect that there was a specific claim for reimbursement or payment of those testing costs in the Bailey case?
No, Your Honor, the opinion does not reflect that. Nevertheless, I don't believe I've ever seen a complaint where there hasn't been an allegation of medical expenses incurred, future medical expenses claimed. Going on, there was also medical testimony in that case on his behalf that he had a greatly enhanced risk of developing a painful, and this is to quote the opinion, a painful and harmful kind of cancer that would affect the lining of the lungs. That notwithstanding, this court held, and appropriately so based on all the pre-existing precedent and the trilogy of cases that came out about the same time, Louisville Trust versus Johns Manville, where this court appropriately extended the statute of limitations to a time when an injury became apparent and manifest. Also, the case of Deutsch versus Schein, where this court held that there was a present physical injury in the form of exposure to x-rays, and then this poor lady, after consulting with her doctor, consulting with her priest, went ahead and had an abortion when she found out that she was pregnant and had an x-ray. That was held to be a physical injury. And then finally, the case of Davis versus Gravis, which addresses the situation Mr. Shelton raised earlier, I think. There was a car wreck. He had a basilar skull fracture. He was afraid of an enhanced risk of future injury in the form of meningitis. The court held that because there was a basilar skull fracture, a clearly observable, identifiable injury, that he could maintain the enhanced risk claim there for the meningitis. That takes us to, I think, the two key cases on which Ms. Wood rests her case.
Well, those cases didn't say you couldn't recover for it. They just said you couldn't recover separately.
They said you couldn't recover separately, and that takes us to the issue of...
That was included in the other.
Yes, Justice, but that takes us also to the issue of, if it's not a separate tort, can it conceivably be a remedy? And the answer, based on capital holding, and this is noted by Judge Kaufman in the Ambergy case and in Cooper versus Luttrell, is only if there is a finding of present physical injury. Then conceivably medical monitoring could be an element of damages.
Tell me how this case would impact the statute of limitations. Let's suppose that we ruled in favor of your opponent here and allowed recovery for medical monitoring, and 5-6 years from now it was discovered that she had this condition that was caused by fen-phen. Would the bringing of this action toll the statute of limitations on that action?
It's a good question, and if I was arguing, I would say no. The response would be, but finally, under Louisville Trust versus Johns Manville, there is now an apparent injury, and the statute starts with that. But what this case does do from a public policy viewpoint, and I've read the amicus brief, of course. I've also read Victor Schwartz's law review article in the Wake Forest Law Review that's cited in the amicus brief. Quite frankly, I think the law review article is substantially better than the brief, and I would commend it to your attention. The brief, however, has one area that I'd like to clear up, and that is the effect that this lawsuit would have on the whole workers' compensation scheme in Kentucky. The argument in the brief, quite frankly, and Mr. Shelton noticed this in his reply brief, it's not clear. I had trouble understanding it. So this is the best I can make of it. If this court were to allow medical monitoring as a cause of action, it would be an end run, so to speak, around the entire workers' compensation scheme. Under KRS 342.690, as we all know, Kentucky has an exclusive remedy provision. When an employer causes something wrong through the employment with an employee's personal health, then that employee has the right to bring a workers' compensation claim. The way the statute is defined, injury is defined in 342.0011, parent 1, as proximate cause producing a harmful change in the human organism evidenced by objective medical findings. And then occupational disease, there has to be a causal connection between the conditions under which the work is performed and the occupational disease. For medical monitoring, where there is no evidence of objective medical findings of a harmful change, then to get it against an employer, one conceivably would go to a class action certification specialist law firm with a 25-page resume like the one you'll find in the motion for class certification in the last 25 pages, where they advertise and say they can get billions for plaintiffs, and where they have direct quotes by judges on how efficacious their representation has been. You go to that kind of law firm, you ask them, what can I do here to get a remedy? I don't have a present manifestation, so I cannot bring a workers' compensation claim. They recommend, file a medical monitoring claim that will entirely circumvent the exclusive remedy provision. That is one of the ramifications that this very simple, narrow case can have.
Mr. Clay,
Yes, sir.
what if Ms. Wood had paid her $1,000 to get checked up? Would she be able to recover it?
She would not be able to recover it unless
She's injured, she's been damaged.
she's been injured. Conceivably, she has
You mean
been damaged.
monetarily?
I
Conceivably.
thought you said she'd been injured.
No, sir.
How is she injured?
She has not been injured, Justice. Excuse me. What she has been is she has ingested, but there has been no injury because there has been no present manifestation of anything whatsoever that's wrong with her. If I said something different earlier, I misspoke and I apologize.
Would you say she's been inconvenienced?
She's been inconvenienced, but I think Justice Liebson spoke directly to that, as did this court unanimously 8 years ago in Capital Holding. Fear and convenience do not state causes of action. They take courts into the realm of speculation. They encourage unnecessary litigation. And consequently, this court should follow the rule that it has followed for at least 100 years. And according to Prosser, Keaton, and Schwartz on torts, jurisdictions across the United States have followed for the last 200 years no cause of action without a present manifestation of physical injuries. One last thing.
Counsel, I take it you would say that because in effect, as a practical matter, that there needs to be something objective. Is that right?
Absolutely, Chief Justice.
And maybe that's good legal policy. I don't know, but the fact is, when a person is subjected to a harmful chemical or drug or something like that, that produces a reasonable apprehension in their mind and has the possibility of causing them physical injury at some time in the future, it's hard to dispute the fact that there is something's wrong has been done to them.
It is hard to dispute. That takes us to a distinction between a potential wrong. And here we don't even have that. She took the diet drug for 6 months. She's totally asymptomatic. And it's probably the vibrations
mean
from
your
my
time
voice
was
that
up.
did that. Does that mean my time is up?
That's not a signal.
All right. In any event, it takes us to a distinction between fear conceivable harm and what is objective and provable. And here, the whole effect of the subsequent research that has taken place with respect to fen-phen indicates that after the individual is off the drug for a period of time, the damage, if any, and here there was none, regresses to the point where it is no longer a problem in most identifiable cases.
But wouldn't that contention, I suspect that there is a body of medical literature and medical opinion to the contrary, as there is on most topics, and wouldn't that go to the evidence?
Here I can safely say that all the scientific studies that have occurred over the last 4 years establish what I've just said. And additionally, here in this case, the class that she seeks to represent is a class, as she is, of completely, totally asymptomatic individuals. If she tries to take the class beyond that, people who have ingested, who were injured by way of having mitral heart valve regurgitation that is more than mild, then she runs into huge commonality, typicality issues in the class that she would love to represent. I want to go back momentarily to the restatement provision that he mentioned. He mentioned restatement of torts too, and that does indeed mention the word harm. Nowhere does it say that upon a finding of harm is there the ability to file an action. You go down to Section 7 of the restatement section, parentheses 3, and there you get a reference to physical harm. And then they take you over and both refer you to restatement second, section 15, and that is physical bodily impairment. And all those they're definitional in character. Finally, the court should and might want to look at the restatement third provisions that we have cited, given the court's citing over the years of the restatement second. And the restatement third of torts in the product section 1 and 21 separate harm between physical harm to the person and harm to property. Now, there are going to be...
Mr. Clay,
yes, sir.
If you was in an automobile accident and you come out of there and you feel a little stiff,
right,
you go have your checkup at the doctor, you're saying the person hit you, ran the red light, is not liable for those medical...
Oh, no, Your Honor. I'm saying that if I feel a little stiff, there is a physical manifestation. And Kentucky law, if I can get over $1,000, is it still a $1,000 threshold, allows me to bring a suit for soft tissue injuries.
Mr. Clay?
Yes, Your Honor.
If we allow this medical monitoring against the pharmaceutical industry, why could we not allow it against the fast food industry because of obesity?
Because of the what?
Obesity.
That conceivably would be a cause of action. I think back to a young man I knew 34 years ago who worked as a roustabout on an oil field. Regularly, I would get soaked in oil as I would saw off leaky underground pipe and replace it with couplings and PVC. I would wash it off, as I was taught to do by my supervisor, with gasoline made by this same oil company that I would siphon out of the back of the truck and then wash it off. I've wondered recently, as I've reviewed all the cases in prepping for this oral argument, if I myself might be a toxic nightmare of some description. I don't have any physical manifestation.
Not only that, Mr. Clay, I really can't see you siphoning gas. I don't know what it is.
I understand, Your Honor.
That was in another life.
Right, that was in another life.
That was an illegal.
It did pay for a year of college. Thank you very much.
Thank you, counsel.
Yes.
Mr. Shelton.
Mr. Clay's arguments are such that I wish I had more than 3 minutes. I will try to move quickly. The first point he raised, Your Honor, concerning my client having an echocardiogram already, I would point out that she did pay for that out of her own pocket. She's asking, at the very least, that she be reimbursed for those costs. There are still numerous
Paid
people
by Medicare or insurance or out of her pocket?
paid out of her pocket, Your Honor. And I would also point out that they've never raised this issue at the trial court level. They never raised the issue at the appellate level. They never raised the issue in the Supreme Court briefs. I would also point out that there's more damage than the heart valve damage that can be caused by these drugs. There's enhanced serotonin levels, and there's also primary pulmonary hypertension, which can kill you.
Serotonin makes you sleep better, doesn't it?
Serotonin is a appetite inhibitor, Your Honor, but if there's too much in your bloodstream, it can cause brain damage. Secondly, I would point out that the statute of limitation would begin to run upon the ingestion of the drug if your sole claim for damages would be medical monitoring. Third, the work comp statute, Your Honors, there's specific provision for a covered injury as exposure to workplace hazards. Mr. Clay argues that yes, but you must show an actual physical injury to bring a claim. I would state that, number one, this court could hold that the work comp statute would preempt a medical monitoring claim because the statute is essentially written, the legislature has essentially written a statute which would prohibit such claims being applied to employers. However, I would argue that this legislature should not be able to do that because this court legislates tort law. And I would point out, for an example, that on the uranium plant in Paducah, where people were exposed to radiation, that certainly there is an excellent case in point for why you need medical monitoring. Who should pay for that? The people that were exposed to radiation or the people that caused the radiation to leak, i.e. the employer? Third, I would point out, if you don't make these drug companies, if you don't make the big corporations pay for this testing, who's going to pay it? It's either going to be the insurance companies, which is going to jack up everybody's premiums, or it's going to be the taxpayers when Medicaid steps in and pays for it. I say that the people that caused the problem should pay for the testing.
Counsel, Justice Graves questioned a few moments ago about where the limits are on this, and he mentioned perhaps facetiously the fast
I was
food.
quite serious.
Well, I said perhaps. Facetiously, the fast food industry, we all ingest products, soft drinks, tobacco products, fast food. Are we exposed to chemicals and fumes of one kind or another on a daily basis? Theoretically, any one of those things could be harmful. With a decision like you're asking us to make, wouldn't we open the door to this host of claims for medical monitoring for a near endless litany of potential harms that people encounter every day?
Your Honor, those doomsday arguments are already addressed by the courts that have approved this cause of action. There are 6 limiting guidelines that a trial court must find first. The second one is been exposed to a proven hazardous substance. A trial court could easily take a claim for fast food exposure and throw it out the window. McDonald's has never been proved to be a proven hazardous substance. I would point out, though, if McDonald's does put some type of chemical in their hamburgers to preserve them longer, and it causes or has the potential to cause serious physical injury, then McDonald's should pay for the testing of every person that ate those hamburgers.
All our high cholesterol tests.
Again, if the medical documentation is there that the hamburgers cause a high level of cholesterol and that therefore it's a proven hazardous substance, then yes, it should be allowed.
We choose to eat those hamburgers.
Yes, you do choose to eat them.
And your client chose to take fen-phen rather than be obese.
This court should not forget that even before you get to medical monitoring damages, you still have to prove your negligence cause of action. And that's apportionment comes into play. All the other factors come into play. If you knowingly take a hazardous substance, you can't prove negligence. And you don't even get to medical monitoring. There are so many hoops you have to jump through in order to get medical monitoring damages.
If you look at the physician's desk reference, a drug is a poison. And for every drug, there are adverse reactions and risks. Any drug we take.
And again, you have to prove liability first and foremost against the tortfeasor under basic negligence or product liability law, even before to even get to medical monitoring damages.
Counsel, you'll have 1 minute to wrap up.
I would again point out, in most of the reservations this court might have about medical monitoring damages have been addressed by court after court before you. And there are 6 limiting guidelines that courts across this country have adopted that limit and address the very concerns that you all are expressing here today. This is not a fly-by-night damage that's being awarded. It is now the norm across this country. I would ask that this court seriously consider to please giving the same right to the citizens of Kentucky.
You did make one statement, this court legislates tort law. In Louisiana, they legislated some tort law, the courts did, and the legislature unlegislated it. Could that not happen in Kentucky?
It certainly could, Your Honor, but I do not think that this court should tie its hands on doing what it thinks is right under Kentucky jurisprudence just because it feels that the legislature might second-guess it at a later date.
The legislature may be the proper place to start.
And I submit to you that this court determines what the proper remedies are for torts in this state, and not the legislature, although they certainly do have a veto power.
Thank you, counsel. Recess court until